So let's talk about conservatorships and having a general understanding of conservatorships. It's really important. The first thing you need to know about conservatorships is that a conservator is always appointed by a judge. And this is a process that is pretty lengthy. In some cases, it means that a petition must be made to the court to bring a person before the court so the judge can determine if that individual has capacity to care for themselves, manage their own personal affairs. There are a couple of different approaches to conservatorships. And again, conservatorships can be very broad or very narrow based on the scope of responsibilities that are detailed in the court order. But once authority is given to somebody to be in charge of another person, they're called a conservator. So there's no special training that needs to occur. There are professional fiduciaries who often become conservators, but in general, anybody who has petitioned the court and can prove that they have the capacity to make decisions for another individual can be a conservator. It can sometimes be family. It can be, other individuals as requested. So there are types of conservatorships too. So one type is over the estate of an individual. Another type might be over the person, the individual themselves. And many times conservatorships are over both the estate and the person. In some cases, there might be multiple conservators. This is less common, but it may be that the responsibilities of the estate and the responsibilities of the person could be split between different conservators. Now, Probate Code 4689 says people have a right to make their own decisions unless a court has taken that authority from them. So you're going to want to know the scope of any conservatorship that a resident or client of yours might have. So, and while we're on that, let's talk about residents' rights to visitation, phone calls, and personal communications. So whether an individual, an agent, is a POA or a conservator, decision-making is often a big part of the role of the POA, the power of attorney, and the conservator. But in most cases, a power of attorney and a conservatorship will not restrict visitation, phone calls, and other correspondence that an individual, a person, might receive. However, Probate Code 2351 states that with regard to visitation, correspondence, and phone calls, they cannot be restricted without express permission from the court. And so again, this is where you're going to want to understand the overall scope of the power of attorney or the conservatorship. So as a best practice, licensees should retain copies of the power of attorney and the conservatorship in the resident's file. It may seem awkward to ask for these things, but do so right at the beginning, at the time that you're signing the admissions documents. If there is a power of attorney that is existing or a conservatorship that is existing, we need to know the details of that. Remember, we are the advocate for our residents and for our clients. It is not our role to take away their rights. In fact, the rights of our residents and clients are very clearly stated in our Title 22 regulations. And so our job is to make sure that our clients and residents retain their rights. And we don't want to see a power of attorney or a conservator removing those rights if they haven't been given permission from the court. So review the PIN for a chart that will explain consent for decision making. This will help you as a licensee or administrator to know when you should act and when you should not. I hope this information is helpful. Thanks again. Talk to you soon.